In the 1970s, the Sydney rail system was rapidly expanding. One project was a rail tunnel from Edgecliff to Bondi Junction. The contract for the construction of the tunnel was awarded to Codelfa Constructions. Codelfa's tender bid and then its construction program proceeded from the basis that they could excavate the tunnel 6 days a week, 3 shifts a day, so 24 hours a day, 6 days a week. On that basis, they would complete the work within 130 weeks. The contract was subject to the City and Suburban Electric Railways Act 1915. Section 11 said, "The Commissioner shall not be liable to have an injunction issued to restrain him from such blasting or by any other operation necessary or proper in connection with the construction of the said work." Both the government and Codelfa assumed that this protection would extend beyond the Commissioner to any contractors. The court decided otherwise and granted injunctions, severely reducing the time each day that Codelfa could undertake blasting. This made it impossible to meet the 130-week deadline and also reduced Codelfa's profits. They claimed additional payments from State Rail, and the dispute ended up in the High Court. One of Codelfa's claims was that the contract had been frustrated. External circumstances, not the fault of either party and not anticipated by either party, had radically changed the nature of the contract. State Rail disagreed. They said nothing had changed. The requirement was still to complete the work in 130 weeks in accordance with the law. The High Court split and there are several important judgments, but Justice Aiken said the grant of the injunction produced frustration in the true sense of that term. It had become unlawful to perform the work in a manner which would have complied with the requirement of the contract, a requirement well known to both parties. The fact that both parties to the contract had an understanding of the law, which led them to believe that the performance of the contract on the 3-shift basis could not be interfered with by any private or public litigant seeking to restrain a nuisance caused by the performance of the work, does not prevent the application of the doctrine of frustration. This case has become a standard authority in Australia for frustration of contract arising from a change in the legal environment in which the contract is performed.